Hello friends, James Corbett here, CorbettReport.com, and before we get into today's eye-opener report, I want to direct your attention to the front page of BoilingFrogsPost.com, where you will find that the second quarterly fundraising drive is now underway with the goal of raising $12,000 to help support Boiling Frogs Post operations, which not only includes the eye-opener report, but of course everything else spilling out across the website, from the nightly news and editorial roundup to all of the podcasts, Peter B. Collins' podcast, Guillermo Jimenez, Andrew Gavin Marshall's podcast, a new video series that's going to be launching very shortly starring Charlie McGrath of Wide Awake News. I'm looking forward to that. Apparently a new podcast that Sibel Edmonds is working on, as well as the book that she's working on for release later this year, The Lone Gladio, which should be very interesting. All of this work supported by your support, and specifically your funds in the last quarterly fundraising drive helped to keep the eye-opener report completely free and open to the public. And just to remind you of the reports that we put out in the past quarter, we had Genetic Fallacy, Monsanto's Silencing Scientific Dissent, Who Decides Who's Crazy, talking about Big Pharma and the Psychological Bible, DSM-5. First Look, looking at that wacky pairing of the fearless crusading whistleblower Glenn Greenwald and his billionaire eBay-owning funder, Pierre Omidyar. Nullify NSA Gaining Ground, a biting example of that witty Corpettian satire. Sibel Edmonds on the CIA and Erdogan. Mind Control in American Politics, a very popular episode there. Anti-War Goes AWOL, Divide and Conquer in Action. Against Fascism, the Separation of Business and State, all of which culminated in the Solutions episode. Unite and Conquer, How to Defeat the Oligarchs. We did Smart Tyranny, another Solutions episode on how to resist the smart grid. 100 Years of War Lies Debunked, a tour de force, if I do say so myself, which I do. How to Steal an Airplane, launching from the MH370 mystery into an exploration of 9/11. Confronting Cognitive Dissonance, another popular episode talking about the psychology of conspiracy theories. Turkey's False Flag Plan, detailing the plan to attack itself in order to blame Syria. Libya War, What They Don't Want You to Know. A Brief History of SSRI Shootings. A conversation with Roger Ver about Bitcoin. And China's War on Terror, about NATO Gladio interference in Central Asia. And just to summarize, that is 4 hours of video content that has been provided to you, completely free and open to the public, 100%, as a result of your support. So once again, this media is made possible by you guys out there, and I do appreciate your support to BoilingFrogsPost.com and of course to CorbettReport.com. And just to be clear, those are two separate entities, never the twain shall meet. Boiling Frogs Post support is very much appreciated, as is support to CorbettReport.com. And on that note, we're going to leave it there, but I'm very much looking forward to your support once again in this endeavor for the Q2 2014 BoilingFrogsPost.com fundraising drive. So let's get straight into today's eye-opener report. Early 20th century writer Franz Kafka was known for creating unsettling stories of characters set upon by unseen forces, caught in the labyrinth of modern-day bureaucracy. A lawyer by training, this sense of angst is perhaps best exemplified in his famous novel, The Trial, in which a man is charged with an unnamed transgression by an unknown accuser in an unofficial parallel court system that begins to take over his entire life. This is the essence of the Kafkaesque. Although often read as an existential critique of modern life, as the unlucky few who are put through the courts can often attest, the Kafkaesque is alive and well in the common law courts of the supposedly civilized Western world. One of the clearest examples of this phenomenon can be found in the courts of Canada, the UK, and similar jurisdictions over the tort of defamation. As Professor Denis Rancourt of U of O Watch explains, defamation laws are an historical relic of the age of nobility, and reflect an exact inversion of the core tenet of Western jurisprudence, that a defendant is innocent until proven guilty.
It is a set of laws that dates back to times when nobles would chase people who criticized them. And it was part of the criminal code in the UK at the time. You will have heard historically of the Star Chamber, and that is where these cases were brought. And so a nobleman could say, well, I was defamed, this person published libelous materials about me, and they could be sent to horrible well, to jail basically, and so on, and fined large amounts of money just in a very very direct way. That's the origin of defamation law under the common law regime, and it has survived. Most of its features, its undemocratic features and its unjust features have survived to this day. So, for example, it is the only cause of action, it's the only tort in law that presumes malice on the part of the person you're complaining against. It presumes malice of defamation. It presumes falsity of what the person said. And it presumes that there has been damage of the reputation. There is no need to prove damage, falsity, or malice. They're all presumed. So you are guilty until you prove yourself through some defense. And the defenses that are allowed are very constrained and very limited and defined in law through the common law. So there's only very specific defenses. If you don't fit into one of those defenses, and if you cannot argue that you're entitled to that defense, you're done. You're guilty. It's the only tort that's like that. It needs to be abolished for that reason alone.
As Rancourt goes on to point out, defamation laws retain their historical roots by remaining almost exclusively the tool of the rich and powerful to squelch criticism by the poor and powerless.
Overall, the courts are a major instrument of power in society. They are tied to the system of enforcement, the police. They're tied to normalizing behavior at all levels, from children and families all the way up to small businesses and so on. And they enforce and deal with banking regulations, the corporate world, and so on. So it's all of that. It's a major system. And defamation law is always a tool that anyone in any of these circumstances can try to use. Of course, if you're a single mother and you've been defamed and as a result you can't get a job, defamation law is not going to help you in any way. You know, the cases where it could help people because of an asymmetry of power, for example, a boss spreads a rumor that a former employee is not reliable, well, you're not going to be hired in that town anymore. That is slander, and that is vicious, and that has huge repercussions. But try to find a case where a former employee has succeeded in using defamation law for his protection in that way. You're not going to find one. And if you are, it'll be the exception that proves the rule.
Sadly, specific examples of exactly how this law is used to silence political discussion of all stripes are by no means difficult to find. A recent example in the Canadian political context is particularly egregious. In 2001, Connie and Mark Fournier founded freedominion.ca as a forum for Canadians to discuss political issues. In January of this year, the forum was shuttered after 13 years of operation when Richard Warman, a human rights lawyer, was awarded $127,000 in damages and legal expenses for comments that were posted to the website by anonymous forum users. Despite having deleted the comments from the website in 2009, the Ontario Superior Court ruled in Warman's favour, barring Free Dominion from ever repeating any of the defamatory comments in any manner whatsoever, and effectively censoring the website from the face of the internet.
We found when we got into court that to try to defend ourselves using the fair comment defense for comments made by other people was impossible, because you have to be able to point to the facts that were relied on and show that true facts were the basis for the comments, and you have to be able to prove that there was no malice in the making of the comments. And obviously, when you're talking about the words of another person, you can't do that. We weren't allowed to even say, well, obviously this person was talking about this particular fact that had come up earlier in the thread, because that was just, it wasn't something that was within our knowledge. So as far as fair comment went, it was out the window when it came to those comments made by other people.
Again, that's head scratching and appalling for so many reasons. I mean, to think that in essence, this goes back to, I think, something we were talking with Denis Rancourt about, is that you are in effect really guilty until you can prove your innocence. And in this case, it's impossible because you have no access to the thought process of the person who posted these comments on your website.
Exactly. And it really applies to the injunction as well. And the reason that we had to shut the website down is because if somebody anonymously came in now and wrote something similar to what had been written in one of these comments about Richard Warman, we would be held responsible. And so even if we saw it 5 minutes later and deleted it, but he had a screenshot of it, he could still go to the court and ask them to file contempt of court charges against us.
The chilling effect of this ruling in particular, and similar rulings in general, is palpable in the Canadian blogosphere. Even the Ottawa Citizen, the only major Canadian media entity to report on the case, chose to close the comment section on the article. In an environment when anyone, anywhere, can leave any comment on a blog that, even if removed within minutes, can still be used to successfully prosecute the webmaster, the hosting provider, the service provider, or anyone else even remotely related to the publication of that comment for defamation, no possibility of free speech or public political debate can exist. There are efforts to reform the system as it exists in a number of jurisdictions. In Ontario in particular, there is Bill 83, an act to amend the existing slander legislation, ostensibly to foster free expression and discourage the use of litigation in stifling criticism. As the Ontario Civil Liberties Association points out in a position paper on the bill, however, Bill 83 would not address the root issue, leaving the dismissal of defamation lawsuits to the judge's personal opinion of whether the case has public interest, and thus further perpetuating the fundamental problem of power disparities and the arbitrary nature of defamation itself. As the OCLA concludes, no real progress will be made on the subject unless the current interest in Bill 83 is instead used to conduct a thorough public examination of defamation law, its pernicious impact on freedom of expression, and its deleterious impact on our society. Until such an examination takes place, the sad fact is that the court system will remain a tool of oppression for the powerful against the powerless, the likes of which not even Kafka could have imagined. This video is brought to you by the subscribers of BoilingFrogsPost.com. For more information on this and other topics, please go to BoilingFrogsPost.com. For more information and commentary from James Corbett, please go to CorbettReport.com.